Justice Watchers, before we begin, I want to make this absolutely clear. The following broadcast contains public domain courtroom footage, commentary, and legal analysis. This content is presented under the Fair Use Doctrine as defined by 17 U.S.C. 107 and is protected by multiple Supreme Court rulings, which you see below. This stream is transformative, educational, and journalistic in nature. It includes original commentary, trial breakdowns, legal interpretation, and critical analysis, not raw redistribution. We do not claim ownership over any public domain footage, and all use is strictly within legal bounds. If you're watching this content, you're engaging in a protected, transformative experience, grounded in law, never in speculation. And if anyone has a problem with that, take it up with Campbell, Brady, Miranda, and Irvin. Remember, guys, justice always works better when we watch. So keep watching. See you in the courtroom.
We stand tall for truth, you see, no chains of doubt, we're running.
USB that the state has used during the course of these proceedings. Located on this are the electronic data that could not have otherwise been given in a physical form. There are also exhibits on here that I have articulated throughout the course of the trial, including the exhibits I used to refresh recollection, search warrants, things of that nature. Counsel and I have reviewed it. There is nothing on this USB other than what was used during trial. Counsel, do you agree to that?
That's correct, Your Honor.
We've also gone through all of the physical evidence, Your Honor, meaning the exhibits and the documents. There are four exhibits that have been removed. They are 1.109, 1.111, 1.110, and 1.117 because they were demonstrative only.
Okay.
I have talked to counsel about the evidence in terms of the forensic crime laboratory reports, as those could be considered continuing witness. Counsel and his client have communicated. They have determined that it is in their best interest to submit those to the jury and that they do not wish to have them extracted. They wish them to go back.
State agrees?
I don't have an objection, Judge. They're welcome to go back to the jury.
Okay.
That would include the autopsy, all the reports from the DNA analysts. That would include the reports from the toolmark expert, as well as the other experts, in this case, toxicology and so on. And counsel, is that correct?
That is correct.
And that was after talking to your client as well?
That is correct.
All right, very well, then those exhibits will go out to the jury.
Thank you, Your Honor.
The only question we had somewhat, Judge, was physical evidence. There are things like bloodstain cards, things of that nature. Counsel and I have talked about it, the totes themselves. Those things were touched by the crime laboratory and obviously are still potentially not something that they should potentially get without maybe some interaction with the court. So we're going to ask that all of the documentary and physical, like photographs, things of that nature, can go back with them. I don't have an objection or need a note for that. But if they wanted to, for example, see the knives or to see the totes or something of that nature, that they would just need to send a note to the court and ask to see
Okay.
them. Is that correct, counsel?
Yeah, we're in agreement on that, Your Honor.
All right, thank you.
Thank you.
Thank you.
All right, anything else before we bring the jury in?
No, Your Honor.
Nothing from the state.
All right, let's bring our jury in. Please turn the phones off or have them on silent. I'm going to have the court reporter hand you the verdict form that we've put together in this case, just to have a look. Here's one for the state. Yes, sir. All right, everyone, please be seated. Good morning, ladies and gentlemen of the jury. Good morning. And I'm required one last time to ask if you were able to abide by the court's previous instructions regarding access to media. Did we have any problems? No. All right, then I will now read you the law that applies in this case. Ladies and gentlemen of the jury, you are considering the case of the state of Georgia versus Nicholas James Kassotis. And this is Bill of Indictment number 2024 R67 in the Superior Court of Liberty County, Georgia, the February term of court 2024. And the grand jury has indicted the defendant with the following offenses: Count 1, malice murder; Count 2, felony murder; Count 3, aggravated assault; Count 4, concealing the death of another; Count 5, possession of a knife during the commission of a felony; Count 6, possession of tools for the commission of a crime; Count 7, possession of tools for the commission of a crime; Count 8, possession of tools for the commission of a crime; Count 9, possession of tools for the commission of a crime; Count 10, possession of tools for the commission of a crime; Count 11, removal of body parts from scene of death; and Count 12, tampering with evidence. Now, you will recall at the beginning of this trial, in fact, in jury selection, the entire indictment was read to you. I'm not going to do that again, but I want to remind you that your oath requires that as you deliberate and go through each count, that you read the entire language that's inserted in each of those counts. So, ladies and gentlemen, the defendant has entered his plea of not guilty to this indictment, and the indictment and the plea forms the issue that you have to decide. Neither the indictment nor the plea of not guilty should be considered as evidence. The defendant is presumed to be innocent until proven guilty. The defendant enters upon the trial of the case with the presumption of innocence in his favor. This presumption remains with the defendant until it is overcome by the state with evidence sufficient to convince you beyond a reasonable doubt that the defendant is guilty of the offenses charged. No person shall be convicted of any crime unless and until each element of the crime is proven beyond a reasonable doubt. The burden of proof rests upon the state to prove every material allegation of the indictment and every essential element of the crime charged beyond a reasonable doubt. There is no burden of proof upon the defendant whatsoever, and the burden never shifts to the defendant to introduce evidence or to prove innocence. However, the state is not required to prove the guilt of the accused beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. A reasonable doubt is a doubt of a fair-minded, impartial juror honestly seeking the truth. A reasonable doubt is a doubt based upon common sense and reason. It does not mean a vague or arbitrary doubt, but it is a doubt for which a reason can be given, arising from a consideration of the evidence, a lack of evidence, or a conflict in the evidence. After giving consideration to all the facts and circumstances of this case, if your minds are wavering, unsettled, or unsatisfied, then that is the doubt of the law, and you must acquit the defendant. But if that doubt does not exist in your minds as to the guilt of the accused, then you would be authorized to convict the defendant. If the state fails to prove the defendant's guilt beyond a reasonable doubt, it would be your duty to acquit the defendant. I charge you that facts and circumstances that merely place upon the defendant a grave suspicion of the crime charged, or that merely raises a speculation or conjecture of the defendant's guilt, is not sufficient to authorize a conviction of the defendant. Members of the jury, it is my duty and responsibility to determine the law that applies to the case and instruct you on that law. You are bound by these instructions. It is your responsibility to determine the facts of the case from all the evidence presented. Then you must apply the law given in this charge to the facts as you find them to be. Your oath requires that you will decide this case based solely on the evidence. Evidence is the means by which any fact that is put in issue is established or disproved. Evidence includes all of the testimony of the witnesses, any exhibits admitted during the course of the trial. Evidence does not include the indictment, the plea of not guilty, and the opening or closing statements made by the attorneys or questions asked by the attorneys. Evidence may be either direct or circumstantial, or it can be both. In considering the evidence, you may use reasoning and common sense to make deductions and reach conclusions. You should not be concerned about whether the evidence is direct or circumstantial. Direct evidence is the testimony of a person who asserts that he or she has actual knowledge of a fact, such as personally observing or otherwise witnessing that fact. Circumstantial evidence is proof of a set of facts and circumstances that tend to prove or disprove another fact by inference, that is, by consistency with such fact or elimination of other facts. There is no legal difference in the weight you may give to either direct or circumstantial evidence. You would be authorized to convict only if the evidence, whether direct, circumstantial, or both, excludes all reasonable theories of innocence and proves the guilt of the accused beyond a reasonable doubt. The jury must determine the credibility of the witnesses. In deciding this, you may consider all the facts and circumstances of the case, including the witnesses' manner of testifying, their intelligence, their means and opportunity of knowing the facts about which they testify, the nature of the facts about which they testify, the probability or improbability of their testimony, their interest or lack of interest in the outcome of the case, and their personal credibility as you observe it. Testimony has been given in this case by certain witnesses who are termed experts. Expert witnesses are those who, because of their training and experience, possess knowledge in a particular field that is not common knowledge or known to the average person. The law permits expert witnesses to give their opinions based upon their experience and training. You are not required to accept the testimony of any witness, expert or otherwise. Testimony of an expert, like that of all other witnesses, is to be given only such weight and credit as you think it is properly entitled to receive. To impeach a witness is to show that the witness is unworthy of belief. A witness may be impeached by disproving the facts to which the witness testified. Your assessment of a trial witness's credibility may be affected by comparing or contrasting that testimony to statements or testimony of the same witness that was made before the trial started. It is for you to decide whether there is a reasonable explanation for any inconsistency in a witness's pre-trial statements and testimony when compared to the same witness's testimony at trial. As with all issues of witness credibility, you, the jury, must apply your common sense and reason to decide what testimony you believe and what testimony you may not believe. The testimony of a single witness, if believed, is sufficient to establish a fact. Generally, there is no legal requirement of corroboration of a witness, provided you find the evidence to be sufficient. I charge you that a statement that the defendant allegedly made while in custody has been offered for your consideration. Before you may consider this as evidence for any purpose, you must determine whether the defendant's statement was voluntary, and if the statement was given in custody, whether the defendant was properly advised of his constitutional rights. To be voluntary, a statement must be freely and willingly given without coercion, duress, threats, use of violence, fear of injury, or any suggestions or promises of leniency or reward. A statement induced by the slightest hope of benefit or the remotest fear of injury is not voluntary. To be voluntary, a statement must be the product of a free will and not under compulsion or any necessity imposed by others. In determining voluntariness, you must also consider to what extent the defendant was informed of his rights, as discussed below. The burden of proof is upon the state to establish that the statement was voluntary. That is, it was freely and willingly made. If you do not find that the statement was voluntary, you may not consider it for any purpose. If you find that the statement was made while in custody and as a result of police questioning, you must also determine whether the defendant was advised of his constitutional rights and whether the defendant clearly understood and knowingly gave up such rights. The constitutional rights that law enforcement officers must explain and that the defendant must understand and voluntarily give up before any custodial statement is taken by law enforcement are as follows. Number one, the defendant has the right to remain silent. Number two, if the defendant chooses not to remain silent, anything he says could be used as evidence against the defendant in court. Number three, the defendant had a right to consult a lawyer before any questioning and to have the lawyer present with him at all times during any questioning. And number four, if the defendant did not have money for a lawyer, that a lawyer would have been provided for him to represent him before any questioning and to be present with him during questioning. The burden of proof is upon the state to establish that the constitutional warnings were mentioned and that they were understood and knowingly given up by the defendant. If you find, as mentioned above, that the defendant's statement was voluntary and that all of the warnings as to the defendant's constitutional rights were given, that the defendant did understand the meaning of what was said and knowingly gave up such rights, then you may consider it as evidence. If so, then you must apply the general rules for testing the believability of the witness and decide what weight, if any, you will give to all or any part of such evidence. If you fail to find that the defendant was properly informed of these rights and that he understood and gave up those rights, then you would disregard the statement entirely and give it no consideration in reaching your verdict. Ladies and gentlemen, evidence relating to DNA comparison has been admitted for your consideration. Identification by DNA comparison is considered opinion evidence and is governed by the law concerning opinion testimony as has been given to you. As opinion testimony, evidence relating to DNA comparisons is dependent upon many factors. Among the factors are the credibility and accuracy of the witnesses who were involved in the process of obtaining, identifying, preserving, recording, and maintaining the physical evidence, and upon the accuracy and validity of the testing procedures themselves that were used to form such opinions. All of these issues are matters for you to consider and determine. It is for you to determine what weight, if any, you will give to the evidence relating to DNA comparisons in your decision in this case. The defendant is charged with crimes against the laws of this state. A crime is a violation of a statute of this state in which there is a joint operation of act and intention. Intent is an essential element of any crime and must be proven by the state beyond a reasonable doubt. Intent may be shown in many ways, provided you, the jury, believe that it existed from the proven facts before you. It may be inferred from the proven circumstances or by acts and conduct, or it may be, in your discretion, inferred when it is the natural and necessary consequence of the act. Whether or not you draw such an inference is a matter solely within your discretion. Criminal intent does not mean an intention to violate the law or to violate a penal statute, but it simply means the intention to commit the act that is prohibited by law. This defendant will not be presumed to have acted with criminal intent, but you may find such intention or the absence of it upon a consideration of words, conduct, demeanor, motive, and other circumstances connected with the act for which the accused is being prosecuted. Every person is presumed to be of sound mind and discretion, but this presumption may be rebutted. You may infer, if you wish to do so, that the acts of a person of sound mind and discretion are the product of that person's will, and a person of sound mind and discretion intends the natural and probable consequences of those acts. Whether or not you make such an inference or inferences is a matter solely within the discretion of the jury. I charge you that a jury is not authorized to find a person who was merely present at the scene of the crime at the time of its perpetration guilty of consenting in and concurring in the commission of the crime unless the evidence shows beyond a reasonable doubt that such person committed the alleged crime, helped in the actual perpetration of the crime, or participated in the criminal endeavor. Members of the jury, the law of our state sets a time limit upon the state in starting prosecution in most criminal offenses. The accused is on trial for the offense of malice murder and felony murder, and under Georgia law, prosecution for these offenses may be commenced at any time. The exact date on which the murder took place is not a material element of the crime of malice murder or felony murder because there is no statute of limitation for those offenses. Prosecution for all other felony offenses included in this indictment must begin within 4 years after the offense has been committed. Prosecution for any misdemeanors included in this indictment must begin within 2 years after the offense has been committed. If you find from the evidence that the indictment in this case was not filed within the required number of years after the offense was committed, it would be your duty to acquit the defendant. Now, ladies and gentlemen, the law provides that criminal actions shall be tried in the county in which the crime was committed. In a prosecution in any case in which it cannot be determined in what county the crime was committed, venue is proper and may be proven in any county in which the evidence shows beyond a reasonable doubt that it might have been committed. Venue, that is, the crime was committed in Liberty County, is a jurisdictional fact and must be proved by the state beyond a reasonable doubt as to each crime alleged in this indictment. Venue must be proven by direct or circumstantial evidence or both. Criminal homicide shall be considered as having been committed in the county in which the cause of death was inflicted. If it cannot be determined in which county the cause of death was inflicted, venue is proper and may be proved in the county in which the death occurred. If a dead body is discovered in this state and cannot be readily determined in what county the cause of death was inflicted, venue is proper and may be proved in the county in which the dead body was discovered. Ladies and gentlemen, I will now charge you on the offenses that are alleged in this bill of indictment. Count 1 alleges malice murder. For malice murder, the state must prove the defendant caused the death of another person unlawfully and with malice aforethought. The killing must have been done with malice to be murder. Malice, as the term is used here, is not necessarily ill will or hatred. Rather, it is the unlawful intent to kill. You may find malice when the circumstances show that the defendant acted with the deliberate intention to unlawfully take the life of another person. You may also find malice when there does not appear to be significant provocation and all the circumstances of the killing show an abandoned and malignant heart. The state does not have to prove premeditation to prove murder. If a killing is done with malice, it is murder regardless of how briefly the malicious intent existed. No specific length of time is required for malice to arise in the defendant's mind. Malice may be formed in a moment, and instantly a fatal wound may be inflicted. If malice was in the defendant's mind at the time of the act or the killing and moved the defendant to do it, that is enough for the killing to be murder. Premeditation typically means a prior decision or plan to do something. Premeditation is not an element of murder and does not need to be proved by the state for you to find malice aforethought. However, in determining whether malice existed at the time of the killing, you may consider any evidence of premeditation or lack of it. The state does not have to prove motive to prove murder. Any evidence of motive has been admitted for your use in determining the defendant's state of mind at the time of the killing. Ladies and gentlemen, count 2, the defendant is charged with felony murder. For felony murder, the state must prove that the defendant caused the death of another person by committing a felony. The state does not have to show that the defendant acted with malice to prove felony murder. Aggravated assault is a felony, which I will define for you shortly. You may find the defendant guilty of felony murder if you believe that he caused the death of another person by committing the felony of aggravated assault, regardless of whether he intended the death to occur. There must be some causal connection between the felony and the death. Felony murder is not established simply because the death occurred at the same time as or shortly after the felony was attempted or committed. The felony must have directly caused the death or played a substantial and necessary part in causing the death, regardless of when the death ultimately occurred. I will now charge you on the elements of aggravated assault. For aggravated assault, the state must prove the defendant assaulted another person with an offensive weapon. To prove assault, the state does not have to prove that the other person was actually injured. However, the state must prove that the defendant attempted to cause a violent injury to the person or committed an act that placed the person in reasonable apprehension or fear of immediately receiving a violent injury. An offensive weapon is an object that is likely to cause or actually does cause death or serious bodily injury if used against another person. The presence of an offensive weapon or the appearance of such may be established by circumstantial evidence. The state is not required to admit into evidence the offensive weapon used by the defendant in order for the defendant to be found guilty of the offenses of malice murder, felony murder, or aggravated assault. I will now charge you, ladies and gentlemen, on possession of a knife during the commission of a felony. For possession of a knife during the commission of a felony, the state must prove that the defendant had a knife with a blade at least 3 inches long on his person while committing a felony, which is one of the following: a crime involving another person, concealing death of another, which is a felony, which I will define for you shortly. And I will now define for you the elements of possession of tools for the commission of a crime. For possession of tools for the commission of a crime, the state must prove the defendant possessed a tool or device commonly used to commit the crimes alleged in the indictment and intended to use the tool or other device to commit a crime. With regard to the charge of possession of a knife during the commission of a felony or possession of tools for the commission of a crime, the state must prove that the defendant possessed the knives or other devices at issue in this case. Actual possession means that at the time of the alleged offense, the defendant knowingly had direct physical control over the knife, tool, or device. Constructive possession means that all times of the alleged offense, the defendant may not have had direct physical control over those knives or devices, but that he did knowingly have both the ability and the intention to exercise control over those objects. Now, ladies and gentlemen, in count 4, the defendant is charged with concealing the death of another. I charge you that the state must prove that the defendant concealed the death of another person, which hindered the discovery of whether that person was unlawfully killed. In count 11 of the indictment, the defendant is charged with removal of body parts from the scene of death. And I charge you that it shall be unlawful for any person to remove from the scene of the death or dismemberment of any person or any human body part thereof. Now, with regard to count 12, where the defendant is charged with tampering with evidence, I charge you that a person commits the offense of tampering with evidence when, with the intent to prevent the apprehension or cause the wrongful apprehension of any person or to obstruct the prosecution or defense of any person, he knowingly destroys, alters, conceals, or disguises physical evidence or makes, devises, prepares, or plants false evidence. Now, ladies and gentlemen, after considering the testimony and evidence presented to you, together with the charge of the court, if you should find and believe beyond a reasonable doubt that the defendant in Liberty County, Georgia, did commit the offenses as alleged in the indictment, you would be authorized to find the defendant guilty of that offense, and in that event, the form of your verdict would be, we, the jury, find the defendant guilty. However, if you do not believe the defendant is guilty of an offense alleged in the indictment, or you have any reasonable doubt as to the defendant's guilt of that offense, then it would be your duty to acquit the defendant of that offense, in which event the form of your verdict would be, we, the jury, find the defendant not guilty. By no ruling or comment that the court has made during the progress of this trial have I intended to express any opinion upon the facts of this case, upon the credibility of the witnesses, upon the evidence, or upon the guilt or innocence of the accused defendant. Your verdict should be a true verdict, based upon your opinion of the evidence according to the laws given you in this charge. You are not to show favor or sympathy to one party or the other. It is your duty to consider the facts of this case objectively, without favor, affection, or sympathy to either party. In deciding this case, you should not be influenced by sympathy or prejudice for or against either party. You are only concerned with the guilt or innocence of the defendant. You are not to concern yourselves with punishment, and you are prohibited from discussing any potential sentences in this case. One of your first duties in the jury room will be to select one of your members to serve as the foreperson. He or she will preside over the deliberations, and he or she will sign the verdict, to which all 12 of you freely and voluntarily agree. You should start your deliberations with an open mind. Consult with one another and consider each other's point of view. Each of you must decide this case for yourself, but you should do so only after a full discussion and consideration of the case with your fellow jurors. Do not hesitate to change an opinion if you are convinced that it is wrong. However, you should never surrender an honest opinion in order to be congenial or to reach a verdict solely because of the opinions of other jurors. During your deliberations, you must not communicate with anyone other than your fellow jurors. You are not permitted to conduct any research. You are not allowed to consult any other materials. And I don't believe that you'll have your phone, so I don't think that's an issue. So whatever your verdict is, ladies and gentlemen, it must be unanimous. The verdict must be in writing and signed by your foreperson, dated and returned to be published in open court. Now, ladies and gentlemen, we have prepared a verdict form that you'll be able to use. You will also have the indictment that fully sets forth all 12 counts. So as you go through the body of the indictment, you can read count 1, you can read through the entire language that is set forth in the indictment, and then you'll see that the verdict form says, we, the jury, in the above title action find the defendant, count 1, malice murder. And there's a block that you can check not guilty or guilty. And it's the same for all 12 counts. So after you have reached a unanimous verdict, and it has been signed and dated on the back page by your foreperson, you would then simply knock on the door, tell the bailiff that you have reached a verdict, although you would not disclose what that verdict is. Then we would bring you back into open court where your verdict will be published according to law. Now, there are going to be a lot of exhibits that will go out with you. These large boxes, the large boxes of physical evidence, we're not going to send those out with you at this time. But if you feel that you need to observe or look at those objects, if you would just simply write a note to the bailiff, and we'll be happy to bring you back out so you can take a look at the object that you wish to see. So I'm going to allow you to go back to the jury room at this time, but you will not begin your discussions and deliberations until you receive the indictment, the verdict form, and all of the physical evidence that will be sent with you. So you are excused at this time. All right, everyone, please be seated. Let the record reflect the jury's now out. Ms. Bayo, on behalf of the state, are there any objections to the charge of court?
There are no objections to the charge or to the verdict form, Your Honor.
Mr. Weinstein.
The defense also has no objections to the charge or the verdict form.
All right, thank you. So we've already reviewed all the exhibits. They're in proper order. I assume we can go ahead and have them sent out to the jury.
I don't dispute that, Judge. I know normally it's the court's practice to have two separate rooms for alternates to not be with the jury. I know we didn't put it on the record. I just want to make sure that that's very clear.
It is, and I've got their names. Let me get the bailiff.
Mr. Weinstein?
Mr. Miller.
I just wanted to make sure.
Okay. The 4 alternate jurors.
asked Mr. Weinstein.
I'm
I
gonna let-
assumed that.
I'm going to let him, always let him stay.
I know, Judge. Thank you. I appreciate that.
All right, then we'll be in recess until we have a verdict.
Thank you, sir.
Ms. Bayo,
Yes, sir.
if you and Mr. Weinstein, and this doesn't, come in.
All right, ladies and gentlemen, please be seated. All right, sir, are you the foreman of the jury?
Yes, sir.
It's my understanding that the jury has reached a verdict.
Yes, sir. Yes, Your Honor.
Is it a unanimous verdict?
Yes, Your Honor.
Has it been reduced to writing?
Yes, Your Honor.
Have you signed and dated it as the foreman of the jury?
Yes, Your Honor.
All right, if you would please hand the verdict form to the bailiff. I'm going to ask that the deputy clerk publish the verdict.
In the Superior Court of Liberty County, State of Georgia, case number 2024R-67, State of Georgia versus Nicholas James Kassotis. Count 1, malice murder, guilty. Count 2, felony murder, guilty. Count 3, aggravated assault, guilty. Count 4, concealing death of another, guilty. Count 5, possession of a knife during the commission of a felony, guilty. Count 6, possession of a tool for the commission of a crime, guilty. Count 7, possession of a tool for the commission of a crime, guilty. Count 8, possession of a tool for the commission of the crime, guilty. Count 9, possession of a tool for the commission of a crime, guilty. Count 10, possession of tools for the commission of the crime, guilty. Count 11, removal of the body parts from the scene of the death, guilty. Count 12, tampering with evidence, guilty. On this 14th day of August 2025.
Do the attorneys wish to see the verdict to make sure that it's in proper form?
No, Your Honor.
And are there any objections to the form of the verdict?
No, Your Honor.
All right. Are there any other requests before we go into another hearing?
No request from the defense, Your Honor.
If I can just have one moment, Your Honor. Nothing concerning the jury, Your Honor.
All right. And does either side wish to place anything on the record before I excuse the jury?
No, Your Honor, and I also don't seek to poll, just for the record.
Nothing from the defense, Your Honor.
Ladies and gentlemen of the jury, we've been here almost 2 weeks, and I wish to thank each and every one of you for your service. It is one of the highest forms of civic duty that any citizen can render to this state and this country, and we cannot resolve important cases like this without your willingness to serve. You've been diligent. You've been here every morning on time. You've been taking notes. You have done excellent work as a juror in this case, and it is sincerely appreciated, not only by me, but everybody involved in the criminal justice system. Your duty ends at this point, and I'm going to have to go into a sentencing hearing. There is one other thing that I do want to mention to you. I think you knew at the outset that this case was going to be televised, live streamed through various media outlets, and I want you to know that you have a right as a juror and as a private citizen. People may want to talk to you about this. Well, at this point, you can talk about it if you want to. That's totally within your discretion. It's my understanding that some of the media outlets may be outside. They may want to speak to you. That's solely up to you. I have no control over that. That's up to you. So when you see individuals who might be with the press or other outlets, that if you want to speak to them, that's fine. And if you don't want to speak to them, that's also fine. So there's nothing else I can tell you other than I sincerely appreciate your hard work in this case. I wish you well, and you are excused at this time. Thank you very much. Yes, ma'am. Everyone, please be seated. And I want to tell four of you, thank you very much for your service. The reason we select alternates is someone whether it's sick or not able to perform their duties as a juror, you would have filled in. But your work was also very helpful to the court. Thank you very much. And you're free to go. All right, ladies and gentlemen, we'll be in recess for about 10 minutes, and then we will begin the sentencing hearing.
Thank you, Your Honor.
Council ready to proceed?
Yes, Your Honor.
Okay. Everyone please be seated. All right, in case number 2024 R67, the jury having reached a verdict of guilty as to all 12 counts in the indictment, is the state ready to proceed with sentencing?
The state is ready to proceed with sentencing, Your Honor.
Is the defense ready to proceed?
The defense is ready to proceed, Your Honor.
Does the state have evidence in aggravation?
Yes, Your Honor. The state intends to call two witnesses and one statement that I will ask Ms. Ashdown, our victim witness advocate, to read. So the state would call, would the court like me to proceed?
Yes, ma'am.
At this time, the state would call Megan Mevin to the stand. Ms. Mevin will be speaking on behalf of the family of Mindi Mevin, Your Honor. Do you wish her to be there?
She might be more comfortable just sitting up there. Please raise your right hand before you're seated.
Do you swear or affirm the testimony that you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do. I just ran up the stairs, so sorry if I'm.
Just hold on. Just catch your breath.
Okay, let's see. All right. I've kept up with the entire trial and decided to drive 3 hours this morning to be here because I couldn't let this chapter of my life end without at least saying something. Unlike you, I have cried a lot over the last few weeks. My thoughts, anxiety, and emotions have been a roller coaster. They have been all over the place while having to deal with this trial. I go through anger, sadness, frustration, grief, stress, and every feeling that you can think of. You lived with us for 15 months with providing no financial contributions. 15 months that I will never be able to get back. At times when you lived with us, I told you how your actions had affected me, and this impact statement isn't much different. Whether you take away anything from this, that is not my intention at this point. You've shown no guilt and absolutely no remorse. You haven't even shed a tear. You thrive on the illusion of power and attention. You're a pathological liar, sociopath, psychopath, murderer. You thought you were so much smarter than everyone else, but you aren't. You wanted people to believe you were a victim of abuse, while you were the one being abusive, at least mentally. You have forever changed the meaning of trust for me and our family. I can no longer trust people in the same way as I did before you continuously lied and ultimately took Mindi's life. There will always be some questions that will go unanswered, but to answer them would mean to try to understand a murderer's mindset, and that is one I will never understand. Mindi was bright, beautiful, empathetic, confident, independent. She loved music and making others feel special. She always put her family and friends first. Once my husband Frank and I had our daughter, Mindi wanted to choose a name that was different than the traditional aunt name. She decided on Lulu. She was never able to hear her sweet niece call her that. My daughter was 5 months old when y'all moved in. She will never know the fun times they experienced together. I'm thankful my daughter does not remember the 15 months you lived with us and sat right next to her at the dinner table. My daughter will never be able to experience the love her Aunt Mindi would have continued to give her. Mindi was taken too soon. No one should have to live through the violent and gruesome murder of a family member. You're a very evil man. When I learned the news of what really happened to Minnie, some of my first thoughts were that I couldn't believe that evil man lived in my house in a bedroom next to my 5-month-old daughter. You have no remorse for what you did. This loss has impacted so many beyond our family. The emotional wound you have caused will never heal. We have comfort knowing she's in heaven now, free from the trials and scars of this earth. We have overcome hatred, darkness, and evil. She is looking down on us now, being proud of how we have overcome. We are done being victims. We are taking back our lives. Since I'm a science person, I'm going to quote Isaac Newton. Every action has an equal and opposite reaction. Our family believes you deserve the maximum sentence, life without the possibility of parole, because Mindi doesn't have a parole. You deserve to sit in prison for the rest of your life and think about Mindi every single day. Thank you, Your Honor.
Thank you.
Your Honor, at this time the state would call Morgan Paddock.
You can raise your right hand.
Do you swear or affirm the testimony that you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
There are people literally all over this world that have been impacted by Mindi's life, and I'm here to speak on behalf of them. I always say my worlds collided with Mindi. Not only was she my high school friend, but after moving to Savannah, all of my college friends became her friends too. My roommates became her roommates. My church group became her church group. This entire trial has rightly been focused on what happened to Mindi, but Mindi was so much more than what happened to her. She was a bright light, vibrant, generous, funny, caring, a defender of others, passionate, trustworthy, and so much more. If anyone in her life would have been in her position, she would be standing right here today speaking for them. Nick, you slowly and strategically tried to dampen her light, isolating her from the people she deeply loved, robbing her of time, laughter, creating memories and peace, always living in fear and isolation. She loved you and trusted you to tell her the truth, to protect her, to live out your marriage vows, and yet you were the one that she needed protection from. Her death has had and will have an eternal impact on those that loved her. There are dinner tables and holiday pictures and memories that will be absent of her. There are little girls growing up without their fairy godmother. There are friends who will always ache to dress up and go out for drinks again. Email inboxes void of her opinions on the latest happenings in politics. Friends who can't expect her to stand with them in their proudest and hardest moments. Friends who won't have her in the audience of their concerts or harassing them for their latest released music. My everyday life in Savannah is now filled with the awareness that my friend was living and suffering within walking distance of my house. And I never knew. I will never be able to drive down 65th Street, go to a Smoothie King, pick up meds at CVS, or buy tennis shoes at our local shoe store without being haunted by the fact that you were frequenting all of those places for 5 months while my friend of over 20 years was suffering in fear and isolation as I drove mere feet from her driveway. But it's not just me and her friends that will miss out. This entire world is impacted by the ending of her life too soon. There are compelling women whose stories she will never get to tell on her podcast. There are strangers who will never know the beauty of the sound of her laughter or the impact of her most fiercest eye roll. Your conviction can't bring her back. It just means that you can't do it to anyone else. But every person you heard from on the stand and the many who are watching right now from a distance will never stop keeping the truth of who she was and her memory alive. You may have taken her life, but you will never be able to take her legacy, and she would want you to know that today.
Your Honor, the state has one final statement that I'm going to ask to be read into the record. That statement would be read by Ms. Samantha Ashdown, our victim witness advocate, on behalf of Samantha Kolyesnik.
And the defense will object to the reading of that statement, as Ms. Kolyesnik, while obviously a victim of the circumstances here, is not a victim under the law that would be entitled to read the statement to the court.
Well, Judge, my position on that, as the court is aware, is that this is evidence in aggravation, not a victim impact statement.
It is. I'll overrule the objection. Thank you, sir.
Thank you, Your Honor.
Yes. There's no need to swear.
To the court and to the Honorable Judge Rose, my name is Samantha Kolyesnik, and I am a victim of the defendant Nicholas Kassotis, aka Nicholas Stark, the latter of which is the name he used while victimizing me in Pennsylvania. You were able to hear my testimony against Nicholas during this trial, and you were able to hear and see my pain and my tears firsthand. I recounted his horrible acts of deception against me. I trembled taking the stand to testify. It was the hardest thing I've ever had to do, but I did it because I feel Nicholas is a true and constant danger to everyone he meets. I feel that if given the chance, Nicholas will continue to exploit, abuse, deceive, and harm others. I testified knowing I would be filmed against my consent and that I would be humiliated in admitting I was defrauded by a man I met online, and that my privacy would be forever gone. I testified anyway because I strongly feel and believe that Nicholas is a danger to society and that he must be held accountable. Ms. Bayo, ADA for the prosecution, mentioned ripples from Nicholas's dropping stone as an analogy for an impact of his choices. I am one ripple. I have not been the same since I found out about his deception from Agent Sands, and I will never be the same again. On the date of his arrest, when Agent Sands of the GBI told me Nicholas Stark was not his real name and that Nicholas had been lying to me, my entire world turned upside down. My sense of trust shattered. I felt humiliated, deceived, traumatized, and unsure if I would ever be able to feel joy or hope or trust again. I also felt stupid and will continuously be called stupid and gullible by some in the public eye, as a result of trusting a man who was once a naval officer, a JAG, an employee of the Pentagon, a man who had every opportunity and privilege in life. Everyone trusted Nicholas, and he knew it. and he privately relished and delighted in lying to them and in abusing that trust. He is a man who delights in deception, a man who thinks he's smarter than everyone in the room he walks in. I also felt terrified beginning on the date of his arrest and thereafter, and will forever be haunted by what he would have potentially happened to me if the GBI and Detective Jack Frost's team had not tracked, found, and arrested Nicholas Stark, aka Kassotis, when they did. I fully believe that the wonderful law enforcement agencies of Georgia saved my life that day, and I will be forever grateful to them for saving me from the evil man who goes by many names, one of them being Nicholas Stark. I was diagnosed with PTSD, post-traumatic stress disorder, as a result of Nicholas Stark's cruel actions towards me. I have nightmares, flashbacks, and panic attacks. I lock my bedroom door every night. I do not feel deceived by Nicholas Stark, aka Kassotis. I feel raped by him. I was not allowed to consent to a romantic and intimate relationship with Nicholas because he lied about his entire identity to me. There was no opportunity for true consent, and he ensured that with his vast network of lies. This is called rape by fraud, but unfortunately is not recognized in Pennsylvania, so all I could do was pursue an annulment on the basis of his fraud. I am sure Nicholas Stark, since he is a lawyer after all, knew those statutory limitations when he deceived me. I do not feel Nicholas feels 1 ounce of shame or remorse for his deceptions against many people, including those he perpetrated against me. He has sat in this courtroom and has attempted to make every mockery of it with his smug expressions, his arrogant demeanor, and his lack of tears as his victims, one after the other, have talked about how he deceived them. I beg and implore and plead to the court, please give this man the maximum sentencing. And please, if at all possible, by sentencing protocol and legislation, please do not allow this man to do paid interviews or in any way profit from his crimes. Nicholas, due to his sick need for control and his sadistic desire to humiliate and defraud others, will absolutely try to profit off his crimes in prison. Please do not allow Nicholas to write books or to sign movie deals or even take paid interviews. He must not be allowed to extract any more from the victims than he already has taken so much. I also ask that he not be granted any chance for parole. A man who lies as much as Nicholas has and will always be a danger to society, especially the most trusting and vulnerable among us. Sincerely, Samantha Kolesnik.
Thank you.
Those are the only evidence of aggravation that the state intends to present. Do you wish the state's argument, or do you wish to have mitigation
I'll wait till I hear
first?
from the defense.
Certainly.
Does the defense have any evidence in mitigation?
Just like to present the defendant's mother to testify in English.
You may.
Father, I'm sorry, Father. One at a time.
So, two witnesses, Your Honor.
Defense calls Wayne
Kassotis.
You can come up here, sir.
I prefer to be here, Your Honor.
That's fine.
Thank you.
Can we swear you in, sir?
Oh, absolutely.
Do you swear or affirm the testimony that you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Absolutely. Good morning, Your Honor.
Yes, sir.
Heard a lot of things in this courtroom this morning. Last over 2 years have been hell for all of us, including Nicholas. Although I don't agree with the verdict that was reached in this court that the jury reached, I do respect the process. They have no idea who Nicholas was. Nicholas is a kind, gentle man that has touched thousands of lives, both as a civilian and as a military person. Nobody saw pictures of him helping underprivileged children in South America as a naval officer. Nobody saw him helping friends as he was growing up He is truly a wonderful, kind person. And from the beginning, when this all broke, from the lies that Agent Sand told to family members, we never believed that this was possible, and we still do not believe that this is possible. We know the person sitting there, our son, as a kind and gentle person that would not do this. And there's really no evidence that showed that he did. I just want you to be considerate and look at the man who he is and who always will be. Thank you, Your Honor.
Thank you, Mr. Kassotis. Thank you very much.
The defense calls the defendant's mother, Linda Kassotis.
And ma'am, you're welcome to stand here, or you can go up there.
Stand here.
If you would please raise your right hand.
Do you swear or affirm the testimony that you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes. Thank you. Your Honor, I would like to say first how incredibly sorry we are for Mindy's family that they had to go through this. We have never spoken since we heard the news of Mindy's death, but we feel incredible sympathy for them that they lost their daughter. But Nicholas was not responsible for this. We know him to be a kind and gentle person. As you know from the testimony, we had not been in touch with him for years through circumstances beyond our control, and every member of our family suffered as a result of that. People missed him so desperately. My mother said she had never gone a Christmas without seeing or hearing from him, and suddenly he was gone from our lives, and we had no idea why. He is a good and kind and gentle person. The thought that he could take someone else's life is just unbelievable, honestly. I respect the jury's work that they did, but they got this one wrong. I'm sorry. Thank you.
Thank you. Anything else, Mr. Johnson?
No, Your Honor.
All right, at this time I'll hear argument from counsel.
Your Honor, may I?
You may.
Your Honor, this case is a case that the court has obviously spent the last 2 weeks present for and listening to all of the testimony. As a result, I don't plan to go over any of that. I think Morgan may have said it best when she described how Mindi and her life impacts the world. When a sentence is rendered, I think the court has always, and I think I've even heard you say, has to evaluate not just how it impacts the defendant, but the message of rehabilitation, if possible, versus punishment, if necessary. The law in the state of Georgia entitles on a murder conviction only 3 options, essentially: the death penalty, life without parole, or life with the possibility of parole. In this case, Your Honor, the defendant is additionally facing all of the additional crimes that can run consecutively. That would be the concealing death of another, which he faces up to 10 years, possession of a knife during commission of a felony, which is mandatory 5 years consecutive, although it could be, of course, probated. And then all of the counts of possession of tools for the commission of the crime that he's facing up to 5 years for each of those. And then the 2 misdemeanors are, of course, up to 12 months. That is more than what I would refer to as natural life. The state's position, Your Honor, is that the defendant should never be released from prison, that he is a danger to society, that his testimony before this court under oath was fraud, that he was dishonest, that he perjured himself, and that, of course, is the state's position. I'm sure counsel for the defense would disagree, and I think that goes to the question, however, of whether or not there is remorse or whether there is some validation to something less than life without parole. The jury has now determined that he not only killed his wife, but that he threw her out like garbage across 3 miles with the hope that no one would ever catch him. If that depravity could not be any worse conduct to deserve life without the possibility of parole, I don't know what could. But for the good work of members of law enforcement, all of the teams that worked so hard to run every detail down, we would not be here today. And so, Your Honor, it is the state's position that the defendant in this case should get the maximum sentence of life without the possibility of parole. The state will defer to the court with respect to all of the other counts, as I essentially believe that they are, you can't get more than forever. Thank you.
Thank you, Ms. Taylor.
Your Honor, the jury has rendered its verdict. While obviously we don't agree with that, we understand that it is your obligation to sentence him under that verdict. Mr. Kassotis is a highly educated man. He's a man that served his country honorably. You've heard a lot of testimony, not just from his parents, but from witnesses on the stand of his kindness. I think there is an opportunity for rehabilitation in this case, especially given his past. So I would ask the court to sentence him to life with the possibility of parole. Those other counts that can be served concurrently, that the sentence have them served concurrently. I understand there's one count that must be consecutive. So that's the position of the defense, Your Honor.
Now, Mr. Weinstein, your client has the right to address the court if he so chooses.
Let me verify. He will not be addressing the court, Your Honor.
Then have him stand for sentencing. Mr. Kassotis, a jury of 12 citizens in Liberty County, Georgia, has now determined beyond a reasonable doubt that you are guilty of the offense of murder, along with 11 other counts. This jury has spoken very clearly. It is now my duty under the law to impose a sentence that is consistent with that verdict. It is also my duty to look at the evidence and weigh the sufficiency of that evidence. And sir, the evidence in this case is supported by a mountain of compelling evidence. This case has revealed a level of depravity that truly shocks the conscience. To put together this elaborate scheme, this web of lies, creating this fictional character, Jim McIntyre, who does not exist. You wrote fiction, and your life was a fiction, at least the last 6 or 7 years. And then you carried out, or the evidence shows that you carried out a brutal, horrific, gruesome murder of Mindi, someone who's been described by various witnesses as beautiful, kind, loving, vibrant, smart. And all of her hopes and dreams vanished in an instant. Her life tragically cut short by you. Someone who professed to love her to care for her. Just the ultimate betrayal. And then you desecrated her body in such a vile way, discarding her remains out in a rural area of Liberty County, hoping that they would never be discovered. This shows beyond all doubt that you have no conscience. When I described to this jury this morning the elements of the crime of malice murder, the language used in the Georgia statute is that the circumstances show an abandoned and malignant heart. That describes you. You have caused so much harm to your own family, to all of those who have been impacted by your deeds. This is truly a heinous crime. So the court has considered all the facts and circumstances of the case. And the court will now impose sentence that reflects the gruesome nature of your criminal conduct. As to count 1, malice murder, the court hereby imposes a sentence of life without the possibility of parole. Although you've been convicted in count 2 of felony murder, that count would merge into count 1. As to count 3, the sentence of the court for aggravated assault is 20 years to serve in the state penitentiary, and it runs consecutive to count 1. Count 4, concealing the death of another, the sentence of the court is 10 years to run concurrently to count 1. Count 5, possession of a knife during the commission of a felony, it's required to be consecutive, so the court imposes a sentence of 5 years consecutive to count 1. As to count 6, possession of tools for the commission of a crime, the court imposes a sentence of 5 years to serve, and that shall run concurrently to the other counts. Court will impose the same sentence on count 7, 5 years to serve, running concurrently. As to count 8, possession of tools for the commission of a crime, again, the court will impose a sentence of 5 years to run concurrently. As to count 9, possession of tools for the commission of a crime, the court imposes a sentence of 5 years, again to serve concurrently. As to count 10, possession of tools for the commission of a crime, the court imposes a sentence of 5 years to be served concurrently. Counts 11 and 12 are both misdemeanors. They carry a maximum sentence of 12 months. The court will impose a sentence of 12 months as to each count, counts 11 and 12, and they shall run concurrently. The totality of the sentence being a sentence of life without parole plus 20 years to serve. Sir, you have a right to seek post-judgment relief from your convictions of these crimes, and you can do that by filing a motion for new trial or filing a direct appeal to the appellate court. That will have to be filed within 30 days of today's date with the clerk of Superior Court in Liberty County, Georgia. If a motion for new trial is made and the court denies it, you will then have 30 days from the filing of that order to file with the clerk a notice of appeal to the appellate level. You also have a right to file a petition for habeas corpus, and that would have to be filed within 4 years of the date that the sentence and judgment in this case is deemed to be final. If you cannot afford an attorney to pursue your appellate relief, a lawyer will be appointed for you, and I'm sure that Mr. Weinstein will discuss with you all of your appellate rights. Is there anything else that needs to be placed on the record before the defendant is remanded to custody?
Your Honor, I just want to clarify. The court indicated life without parole for count 1, 20 years to serve consecutive on count 3, and 5 years to serve consecutive on count 5. Is that correct?
Correct.
Then that would be life without parole plus 20.
That is correct.
I just want to make sure the record was
I
correct.
misspoke.
Thank you, sir.
It's mandatory by law.
Correct. I just wanted to clarify.
Yes, ma'am.
That's the only position of the state.
He is remanded to custody. Court stands adjourned.